for your arrest.
You practice in front of bench. That's my job or my attorney job. I'm sui juris. I'm appropriate person.
Okay, Mr. White, I don't know where you read the stuff that you're saying, but it's legal nonsense.
I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace, and
sir.
I'll travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White.
All right, guys.
All right, everyone. Today we're watching a courtroom moment where a judge comes face to face with a self-represented defendant who believes the rules don't apply to him. This exchange quickly becomes tense because the defendant keeps talking over the judge and refuses to follow simple instructions. As the hearing goes on, he makes a serious misstep, and the judge firmly brings the situation under control. It's one of those moments that really shows how authority works.
All right, on the telephone ending in 1336, tell us your name, please.
I come in sui juris.
Only one of you actually has that phone number, and the other people are just wrong about what their phone number is. Who's calling ending in 1336?
Sui juris and personal persona. I'm Stephen hyphen Tyrell colon White comma beneficiary and sovereign. I'm here under fraud, menace, and duress. Fiduciary Daniel Williams Norbeck.
Okay, Mr. White, we're going to pop you over in the waiting room because you're just going to be a distraction for all the citizens here willing to abide by the laws of our country. So we'll pop you over in the waiting room and we'll get back to you. In case you guys have ever heard of the term sovereign citizen in the news, that's what one of them sounds like when they try to come to court.
In a courtroom. As we get into it, pay attention to how the judge manages the situation. Personally, I think he handles it very well. He stays focused, calm, and doesn't let the hearing get derailed, even when the defendant keeps pushing.
All right, Mr. White, are you able to hear me?
Your Honor.
All right. I'm going to read this to you so you understand what you're charged with. This says that on January 7th of this year, on 2nd Street there in the city of Fenville, that you were driving while license suspended. That is a misdemeanor. It's punishable by up to 93 days in jail and or $500 fines and costs. You understand your charge?
Objection, Your Honor. I do not. I do not understand my charges or
okay. I'm going to mark you down as not guilty, and we'll set you for a jury trial. You can continue to.
Your Honor. Your Honor. You practice in front of bench. You practice in front of bench. That's my job or my attorney job. I'm sui juris. I'm appropriate person.
Okay, Mr. White, I don't know where you read the stuff that you're saying, but it's legal nonsense. It means nothing in a court of law. So if you're not willing to state that you even understand or recognize the authority of the court, my options are I can make you come in for arraignment and not give you a PR bond, and then you'll have to post bond to not sit in jail. You want to do it that way instead? Right now, if I get through arraignment with you, I'll give you a PR bond. Mr. White?
I don't listen. I'm asking you a question.
What's the question, sir?
I'm not arguing with you, Your Honor. I just want you to hear me. Okay,
but I don't want to listen for 20 minutes. Go ahead and ask your one question, and we'll start there and see if it's a real question.
Am I on the record?
Yes.
It's not going to take 20 minutes, Your Honor. I'll give you my word.
Well, you said you have a question, sir. What's the question you want to ask?
Is this criminal or is it civil?
This is criminal, sir. It's punishable by up to 93 days in jail and or $500 fines and costs.
Hey, if it's criminal, can I ask to dismiss the charge?
That was too
back. Let's dive in and see how it all unfolds. From the start, you can tell this judge is straightforward and all business. He's already worked through the rest of the court schedule and has kept this defendant waiting, which may have been intentional. Now we'll see whether that pause changes the defendant's attitude at all. The defendant asks multiple questions at once and demands the case be dismissed, but the judge makes it clear that isn't how this works. This isn't even a trial yet. It's just a preliminary hearing. The defendant throws around...
Because at this point, the prosecutor... There's no sworn testimony. There's no sworn.
It's because this is just arraignment, sir. What you're talking about is trial. That would be several steps down the road. Arraignment is just for you to make sure that you understand what you're accused of, what the penalty is, and for you to enter a plea. You're accused of driving while license suspended. I read to you what the possible penalties are, and I asked you if you wish to plead guilty or not guilty at this time.
No, Your Honor, I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace,
Okay, sir, those sentences don't mean anything. They have no legal meaning whatsoever.
It's guaranteed by
So
my
I've
constitutional
indicated that since you can't understand arraignment, I've entered a plea of not guilty on your behalf. I've set you for a jury trial. You can represent yourself free of charge, or you could hire an attorney. And now you must make a choice, sir, for bond. If we get through the arraignment with you on Zoom, I'm going to give you a PR bond, personal recognizance bond. That means you don't have to post any money. We're essentially trusting you that you'll keep coming back for your court dates. It is no driving without a valid driver's license. If you cannot get that far, in other words, if you really don't understand what's happening here, then I'm not going to allow you to be arraigned by Zoom. I'm going to set you for arraignment in person. And you will come to this courthouse. You will not get a PR bond. You will get a $300 cash or surety bond, meaning that you will need to post $300 in cash, or you will sit in jail from that day until your trial date. So I'll give you a choice. Do you want to be arraigned over Zoom like we're doing today, or would you like to come in and be arraigned in person?
Well, I object to all this, Your Honor, because at this point, I don't even understand the charges. I do not understand the charges. I'm not trying to.
That's fine. No, sir, you're allowed to. Sir, you're allowed to object, and I understand your sentence that you don't understand the charges. And so I will attempt to work with you for that for a second. I'm going to read the charges to you, okay? This says that it takes place on January 7th of this year. You understand that, right? The date that I just read.
I'm saying I do not. At this point, Your Honor, it's I was saying this. It was a jurisdiction matter. It's a jurisdiction matter. That's what I'm saying. It's a subject matter,
Sir,
jurisdiction.
Here's the problem with you arguing jurisdiction. I am a lawyer, so I understand what jurisdiction means. I'm not sure you do.
Legal terms as if he fully understands them, but it's obvious he's confused about where he is in the process. He's already struggling with basic procedures, and that puts him at a disadvantage right away. Let me know what you think while watching. Should the judge have ended the hearing early, or was it better to let things play out a little longer? What really stands out here is the judge's approach. He doesn't get emotional, and he doesn't fall into the usual traps that often come up in these situations. Some judges get frustrated or allow too much back and forth, but this one stays composed and professional. He shuts down distractions without raising his voice, which shows confidence and experience. I know some viewers might feel the judge is being too strict, so I'm curious what you think.
The accusation is that you're driving around on 2nd Street in the city of Fenville, meaning in Allegan County, and that you're doing so when your driving privileges with Secretary of State have been suspended or revoked. Because this is the county. Yes?
Objection. I travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White. You are no longer able to be arraigned by Zoom. What I'm going to do is adjourn this. I'm going to adjourn this, and you will get notice at your address there. You will come in, and we will arraign you in person. I'm telling you that I'm not going to give you a personal recognizance bond, sir.
It has to be before we can proceed.
White,
before you can proceed, it has to be addressed, Your Honor.
Because we are on the record, I'm going to make this infinitely clear. You're going to get notice to appear in front of me. You have two choices. If you do not appear, I'm going to put out a bench warrant for your arrest. If you do appear, we will have this conversation again about arraigning you to see if you understand the charges, but you are not getting a PR bond. You will need to bring with you $300 cash or surety, or you will be in jail. Do you understand? Those are two options, A and B.
That's a violation of my constitutional rights, Your Honor.
Well, no, it isn't, sir. So we're all set for today. We're done talking. We cannot make any progress. You will be asked to come in person for arraignment. You can either choose to come in for arraignment or you can choose to not be here. If you choose to not be here, a warrant will be entered for your arrest. And if you do choose to be here, make sure you bring that $300 because you're not getting a personal recognizance bond. But we are done with this hearing. I'm going to go ahead and release you. Thank you.
When's my date for court?
Man,
In my opinion, he's striking the right balance. Firm but respectful. Even after the judge clearly explains that the next court date will be sent by mail, the defendant still seems confused. It looks like he's more focused on sticking to a memorized script than actually listening. If he had paid attention, this could have been resolved much more easily by accepting responsibility, paying a fine, or completing required steps. Instead, his refusal to cooperate only makes things worse and could lead to more serious consequences. That's what's so puzzling about situations like this. The court often offers a straightforward path forward, yet some people choose to argue and complicate matters instead. The law is fairly clear. Show up, listen carefully, and handle the issue responsibly. Trying to argue technicalities rarely helps and often backfires. That said, these moments do make for interesting viewing. I'm going to wrap it up here. If you enjoyed this video, please like and subscribe for more content. I'd really like to hear your thoughts. Do you think the judge handled this the right way? Or do you feel he went too far? Thanks so much for watching, and I truly appreciate your support. Take care.